The doctrine of separate but equal has no place. Separate educational facilities are inherently unequal.
I grew up in a world in which people like my grandfather, for example, had 9 months of education in one of these one-room schoolhouses in rural Georgia. So education became the sort of the holy grail. It was the way out. People would often say, if you get it in your head, they can't take it from you.
Brown versus Board of Education is the single greatest moment, single greatest decision in this court's history. And the reason for that is that it enforced a constitutional principle, equal protection of the laws, equal justice under law, and made that real for all Americans, and corrected a grave wrong, the separate but equal doctrine that the court had previously allowed.
In 1896, in Plessy v. Ferguson, the court ruled 7-1 that separate but equal facilities were constitutional. The sole dissent was that of Justice John Marshall Harlan.
He recognized that people in their private dealings had prejudices and looked at color. He recognized that society looked at color. But he went on to say that the Constitution knew no color. You could not use the Constitution of the United States to sanction laws based on color.
Plessy was wrong on the day it was decided. In fact, we've recently said it was egregiously wrong. But it remained the law of the land for 60 years. There's an important lesson in that. In vast majority of cases, the Supreme Court follows its past decision.
This is Thurgood Marshall. All right, that's Thurgood Marshall. We're talking about art and activism, the art of protest. I got a writ of certiorari for Illinois and a writ of certiorari for Maryland. You'll talk about Plessy versus Ferguson, but we're going to talk about DRED Scott. And you got my paperwork. DRED Scott 2025. Do blacks have rights?